Hi, thanks for tuning in for another dose of bite-sized bits of knowledge where we give you meaningful information in a short amount of time. In my last video, we talked about litigation, finally, and the parties, the pleadings, discovery vehicles, trial, and some, a couple extra little things on top of that. In this video, I want to talk about alternatives to litigation. There are a few, okay? First, I would say would be mediation. Mediation usually is an obligation in litigation. Judges are typically saying, go to mediation. There's a court-ordered mediation. Try to see if the parties can settle outside of court, privately. Mediation is one thing. I'll get into that in a second. The alternative is arbitration. Arbitration is a little bit more of a formal venue. It's like a kind of like a court, but there's a judge or a panel of judges, and they hear the case and they rule. So we'll talk about that as well in a minute. Mediation usually has like a retired judge or a certified mediator who's been a lawyer and they know how that works. And both parties go to mediation. They sit at the table. They make angry faces at each other, and everybody's angry usually. And the mediator does their spiel where they say, how it works, and, the likelihood of litigation is expensive, and all the things I just told you in my prior video. They'll give you the riot act. And then they'll let usually each party present a case, and then they'll break up into caucuses separately. And the mediator will run back and forth between the rooms, or in Zoom meetings. They'll run back and forth between the rooms, meeting with each of these different parties separately and kind of beating them up to make it, clear that their case is not as meritorious as they may think it is. And just keep doing that back and forth until there's maybe some talks of settlement, and it could take a while, but it's a very meaningful process. I would highly recommend building them into your contracts as a requirement in good faith before proceeding to arbitration and before proceeding to litigation. It's just cost-benefit no-brainer, in my opinion. On the other hand, arbitration, some lawyers love it, some lawyers hate it. Arbitration is where you're submitting your case to a panel of one or more judges, and they hear your case. You get to put on your case and your evidence, and you have a discovery process, but it's just not the same as court. It's not as comprehensive as court. And so most litigators that I know prefer the court system. It's just, if you want to, have access to information and bubble facts at the top, you want to use the court. Sometimes it might make sense to have a more cost-effective, quicker process in arbitration. And so you'll do your case, you'll get some information, and then the panel will ultimately decide, in a binding way. There is non-binding arbitration, but then that leads you back down to litigation. So that's okay too. Some contracts have provision that says, mediation first. If there's conflict, then arbitration or litigation, depending on what the parties can agree. So this is something called ADR, alternative dispute resolution. It's a big area. Given how backlogged the court system is, alternatives are needed and desired. And again, some lawyers like it, some lawyers don't. They all have good arguments in both directions. As a planner, someone who's trying to keep you out of court and save you money and eliminate conflict, our contracts have things like this in them to try to mitigate the blow up and try to see if parties can really come together and make a resolution so that there's not a grenade going off. And then ultimately a resolution later after everybody's tired and has less money in their wallet. So I hope you found this particular video helpful. Thank you for tuning in, and stay tuned for more.